From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court issues a big ruling on the Second Amendment, allowing domestic abusers to be disarmed via civil restraining orders, while refusing to strike down a 2017 tax that some say could pave the way for a wealth tax. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Kim Strassel and Alicia Finley. It was another big week at the Supreme Court as the justices get ready for their summer break and try to get those final opinions out the door. A bevy of rulings on a water dispute between Texas and New Mexico, unanimous jury requirements under the Fifth and Sixth Amendments, and more. But let's go straight to the top headline out of the court on Friday. This is a case called U.S. v. Rahimi. It involved a man named Zaki Rahimi who received 73 months in prison under a 1999 federal law that prohibits firearm possession by people who are subject to certain protective orders. And Kim, to my eye, there's no argument here that Mr. Rahimi is not the kind of person who should have access to a firearm. According to the government's briefs, he threatened to shoot his girlfriend after a bystander witnessed a physical altercation with her in a parking lot. He fired his gun potentially at that witness. He shot at the house of a man to whom he'd sold drugs and fired in the air in apparent road rage incidents. The question here is whether this civil restraining order meets the Second Amendment requirements. And remember, in 2022, there was a landmark opinion from the Supreme Court called Bruin that said gun regulations, in order to be upheld, had to be consistent with this nation's historical tradition of firearm regulation. That was the phrase in the Bruin opinion from Justice Clarence Thomas. So, Kim, what did the Supreme Court do in this Rahimi case?
They broadly agreed that it was okay for people to be disarmed if they have been subject to these civil restraining orders for domestic abuse. They held to the Bruin history generally by pointing to some common law history, also laws that some states adopted going back all the way to the early years of the founding. One were called surety laws, and these were laws that essentially a magistrate was able to require a person for whom that there was a probable ground to suspect of future misbehavior to stipulate that and to give assurance that they would not. And one of the things they had to do was post a bond, and the opinion goes through ways in which they consider that similar. They also talked to what was called going armed laws, which were generally prohibitions. Certain states had these going out into public armed with the purpose of engaging in a fight. And so they did offer some historical background for why they felt this could be maintained and be found consistent with the Second Amendment. But what I think is really, really important here, and what I think is the best part of this opinion, is the formulation and the specificity of its main holding. And let me read that. This was written by John Roberts. He said, "When an individual has been found by a court to pose a credible threat to the safety of another, that individual may be temporarily disarmed." And I just want to point out a couple of words in there. One is the when an individual. Okay, so what the court is saying here is, no, this is not a green light to pass gun regulations that would disarm groups of people. That doesn't work that way. When an individual is found to pose a credible threat to the safety of another, so that's also pretty specific. It doesn't necessarily suggest that you could have an order just saying this person in general seems to be unhinged and therefore we're going to take their gun away because it might pose a risk to public safety at large. That does not seem to be what this is saying. Then they can be temporarily disarmed. And so the court also went out of its way to say that this stripping of your Second Amendment rights lasts only as long as does the restraining order. It's not a permanent prohibition. So this strikes me as a basis on historical readings, and they came up with this very specific definition. This, to me, again, does not strike me as open the floodgates to a bunch of regulation in any sort of manner. I think it was very specifically a message that on case-by-case basis, when there is a judicial process involved, evidence has been presented, a judge makes a decision about the risk of violence from one person to another, there can be a temporary stripping of the Second Amendment right.
To underline that point about the narrowness, the Chief Justice, in his opinion, says that this is someone who has been found by a court to pose a credible threat. And there's another section of his opinion that zeroes in on a different word, responsible. Let me read that. It says, "We reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Responsible is a vague term. It is unclear what such a rule would entail, nor does a line derive from our case law." So there, I think the majority is clearly making a distinction that the Second Amendment is a fundamental right. In order to remove that fundamental right, showing that somebody is not a responsible citizen is not enough. There has to be a specific showing on a threat of violence occurring from that person. Part of the disagreement, this is an 8-1 case, so most of the court coming along, but part of the disagreement is on the level of analogy, Alicia, which I think is something that makes this case fascinating, because the majority is not stepping away from the framework that was laid out by Bruen, that gun laws need to be consistent with the nation's history and tradition of gun regulation. But there is some disagreement on what the level of analysis is, and notable that the one dissenter in this Rahimi case is the author of the Bruen decision, Justice Clarence Thomas. He says in his dissent that not a single historical regulation justifies the statute at issue. And there's a good bit of the Chief Justice's opinion that is responding to that. Let me read that. The Chief Justice says that previous precedents were not meant to suggest a law trapped in amber. He says the Second Amendment permits more than just those regulations identical to ones that could be found in 1791. Holding otherwise would be as mistaken as applying the protections of the right only to muskets and sabers. So, Alicia, a bit of fascinating disagreement between the originalists on the court about how you go about applying these kinds of history and traditions tests. How close does a law that is being challenged have to be to a law that you can pull out of the founding era?
Well, I think the Chief Justice says it right, that it doesn't have to be a historical twin. It must just be historically analogous, which is consistent with their holding in DC, or the Heller case and the McDonald case, which were the original landmark precedents going back more than a decade ago that upheld the individual right to bear arms and carry a handgun in the home. And as you pointed out on the Chief's opinion, that we were to try to have historical twins. Well, firearms today are very different than they were at the founding. So, there weren't bump stocks, there weren't semi-automatics or automatic machine guns. So it would be very difficult to find any kind of direct historical twins or direct historical precedents for a lot of these kinds of laws. But that doesn't necessarily mean that they aren't constitutional. And then I think the Chief actually points out that there are certain limitations on the Heller case, or the Heller decision, and the McDonald, and that this was not just a blanket decision that enshrined a Second Amendment right to carry arms whenever, wherever, and whoever want to. The Congress or the states can pass some reasonable restrictions so long as those restrictions have some kind of a historical analogy. Now, where I'm more sympathetic to Clarence Thomas's position is he worries about the slippery slope and how the liberals could use that kind of argument to say, well, maybe this wasn't historically analogous, and they may try to erode the Heller and McDonald precedents on that basis. And if you broadly give judges the authority to deem someone a risk and disarm them, where does that stop? I mean, I think Kim has pointed out in the past that could judges disarm someone for just speeding? The Chief Justice says, well, or in the majority opinion, well, simply the government claiming that someone isn't a responsible citizen, that's not grounds. But what could be grounds, and where do you draw that line? And could the government use this kind of decision to try to impose more restrictions on other people, if you're on a no-fly list, for example, from owning guns, and thereby use that as a backdoor to watering down the Heller and the McDonald precedents?
Hang tight. We'll be right back in a moment. Welcome back. After the majority opinion in this case, then come a series of fascinating concurrences by the conservative justices, Kim, where they are giving their own interpretation of this question. Here's a line from Justice Amy Coney Barrett. Analogical reasoning under Bruin demands a wider lens. Historical regulations reveal a principle, not a mold. So that's her view of this. Justice Neil Gorsuch says, whatever indeterminacy may be associated with seeking to honor the Constitution's original meaning in modern disputes, that path offers surer footing than any other this court has attempted from time to time. And then there's also one by Justice Brett Kavanaugh, and he goes into a similar sort of argument. He says, absent precedent, there are really only two potential answers to the question of how to determine exceptions to broadly worded constitutional rights: history or policy. And then he comes down squarely on the side of history and does a pretty solid attack, I think, against the court using balancing tests in which judges are supposed to decide whether the benefits of a regulation outweigh the costs of a regulation. Kim, what do you make of this? I think this is an interesting phenomenon here where you have a case that is decided 8-1, and then you end up with all these concurrences showing the conservative justices trying to think out loud about how their originalist philosophy is supposed to be applied in practice.
Yeah, this was a complicated question. By the way, I would note that one of the reasons that we're having to confront these questions now actually goes to a very valid point that Clarence Thomas made years and years ago, complaining that even in the wake of the Heller decision, which did not come until very late in recent history, which affirmed the Second Amendment was an individual right to bear arms, that the court ducked its responsibility in the years following to then elaborate upon that and provide some specificity. So we're now in some uncharted territory as we look to how you fill in the contours of that broad holding. And this was, I think, a fascinating opportunity for the justices to really, as you say, meditate on some big subjects. Some of these concurrences, I think, should be read as a collegial and thoughtful response to Thomas's dissent, trying to make the case for why they went down the historical path the way they did. And I've seen a number of commentators rightly suggested it. It's very invigorating and enlightening to see these justices disagree with each other on serious academic questions, ones with practical implications, obviously. I was really happy to see the Kavanaugh broadside, as it were, on balancing tests as an argument for why they turned to history. He kind of took some real pot shots at scrutiny and all the different types of scrutiny that judges try to use to water down core rights because they're trying to shoehorn in their own policy outcomes out of it. I thought that was a very interesting thing. Also very interesting was Gorsuch's concurrence, in which I think is a reassurance and a reminder to anybody out there that thought that this was some sort of huge smack against Bruin. He went out of his way to say the things that had not been decided with this opinion. And I will just read a little bit of that. He says, "We did not decide today whether the government may disarm a person without a judicial finding that he poses a credible threat to another's physical safety. We did not resolve whether the government may disarm an individual permanently. We did not determine whether this statute may be constitutionally enforced against a person who uses a firearm in self-defense, nor do we purport to approve in advance any other laws denying firearms on a categorical basis to any group of persons a legislature happens to deem, as the government puts it, not responsible." So he's mirroring what the Chief Justice said there. But I think that was a really important concurrence in explaining that this case really was aimed at domestic restraining orders that go through a judicial process where evidence is presented. You have to prove an individual is a direct harm to another person's safety and that this is temporary.
A couple more thoughts on that. One is that, Alicia, this strikes me as another case where much of the punditocracy was unduly alarmed. And I don't know how many times this has to happen before they will figure it out. But here are some of the headlines from 2023 when the Supreme Court decided to take this Rahimi case. The Supreme Court will decide if abusive spouses have a right to own guns. Rahimi, the case that might turn the court even more extreme on guns. And SCOTUS is really considering if domestic abusers should be allowed guns. And now we have an outcome here that is 8-1. And those are tendentious headlines, even if it had gone the other way, because the ruling then would have just been that a higher due process standard is required before disarming someone like Mr. Rahimi. But it is remarkable to me, Alicia, how many times we can go through this panic cycle. Is the Supreme Court going to strike down Obamacare on a technicality? Well, no. Is the Supreme Court going to overrule the FDA's regulations on mifepristone? Well, apparently not. Is the Supreme Court going to put guns into the hands of domestic abusers? No, it is not going to do that.
Right, and I would make one additional point is here the Supreme Court overruled the Fifth Circuit on this, which actually is what the left used to fearmonger about this case. Now, also the FDA case, the mifepristone case that was decided last week. And it was similarly, there was a Fifth Circuit judge that ruled on Obamacare. And so you're actually seeing some of the Fifth Circuit conservative judges get increasingly overruled by the Supreme Court, much like the Ninth Circuit judges often do. And I would hope that this would create more caution and more circumspect judicial rulings from the Fifth Circuit, because some of them have been quite sweeping. And because these rulings, the Fifth Circuit, and there's another couple involving social media laws out of Texas, Florida, actually, that's not the Florida one isn't the Fifth Circuit, but the Texas one is, that may also be overturned on appeal. And I think some of these rulings are just so sweeping that it emboldens the left and it allows them to make these claims that the Supreme Court is about to overturn this or do this or that, and when they actually put some restraints and actually end up overturning the Fifth Circuit's judges that probably go too far in their rulings.